Have you ever heard of going to court, having the judge disagree with you on all the facts, and still winning your case? Well, that is exactly what happened when two homeowners decided to take on their HOA. They ended up winning on a technicality so obscure, it sounds like something straight out of a legal thriller. This is the amazing story of the 45-day rule.
So let's just dive right into that central question, because it seems impossible, right? You lay out your entire case, the other side lays out theirs, and the judge basically says, yeah, on the merits, I don't agree with you, but you still walk away the winner. How does that even happen? Well, that's exactly what we're going to unpack here.
All right, so let's set the scene. Meet Stephen Hedden and Paul Ryan. These two guys were homeowners in a pretty upscale community out in Fountain Hills, Arizona. We're talking multi-million-dollar custom homes on these beautiful adjacent lots. And they had an idea that, to them, seemed completely reasonable. Okay, so their homes shared this long, 300-foot private driveway. And because it went up and over a small hill, a lot of people would mistakenly drive up it, thinking it was a real road, only to have to awkwardly back out again. So, on May 1st, 2006, they put in an application to their HOA to install a nice electronic gate. You know, for privacy from those looky-loos, safety for their kids, and hey, a little boost to their property value. Seems simple enough. What could go wrong?
Well, what started out as this really straightforward request quickly turned into a total bureaucratic nightmare. The homeowners found themselves completely stuck, just bouncing between different HOA committees with no clear answers and no clear path to getting one. It was a classic runabout.
And this timeline here really just maps out the whole frustrating journey. So they submit the application on May 1st. About a week later, the Design Review Committee, let's call them the DRC, punts the decision to the main HOA board. Then a week after that, the board just sends it right back down to the DRC. It wasn't until July 5th, more than 2 months after they started, that they finally got an official denial.
So here's that first move. On May 10th, the DRC basically decided this whole gate thing was a little too different for them. Apparently, no other home had a private automatic gate like this. They were worried it would set a big precedent, so instead of making a call, they just kicked it upstairs to the HOA board.
And you won't believe it, but just 1 week later, the board essentially said, nope, not our problem either. They brought up some objections, mentioned a neighbor wasn't too thrilled about the idea, and then passed it right back down to the very same committee that had just sent it to them. The homeowners were officially trapped in a bureaucratic loop.
Now, during all this back and forth, the HOA came up with this new standard. They told the homeowners that for a request this unusual, they needed to provide a compelling reason. But here's the real kicker. That phrase, compelling reason, it wasn't written down anywhere, not in any of the official community rules or documents. They basically just made it up on the spot to justify their position. So, as you can imagine, this whole dispute eventually landed in front of an administrative law judge. Both sides showed up ready to argue about the actual gate itself, and this is the part where you think, okay, this is how the case is going to be decided. And you can see the arguments laid out pretty clearly here. On one side, you have the homeowners, saying the gate is about safety, privacy, and boosting their home values. On the other side, you've got the HOA, countering that it's a bad precedent, some neighbors don't like it, and hey, our existing community security is perfectly fine. So just looking at these points, who do you think has the stronger case? Is it the homeowners with their focus on their own private property rights? Or is it the HOA focused on community standards? The judge heard all the evidence from both sides and had to make a call. And the answer, incredibly, was neither of them. The judge's final decision had almost nothing to do with whether the gate was a good idea or a bad idea. All those arguments we just saw about safety, property values, precedent, they all ended up being totally and completely irrelevant.
That's because this case wasn't won or lost based on arguments. It was decided by the calendar. The real key to this whole thing was a clause buried deep inside the HOA's own rulebook, a rule that it seems everyone, especially the HOA, had completely forgotten about.
And this right here, this is the whole case. Section 11.4 of the HOA's own governing documents said it crystal clear. If the committee doesn't give you a written decision within 45 days, your application is automatically approved. Deemed approved. No ifs, ands, or buts about it. So, the most important number in this entire story is this one. The HOA and its committees had spent more than 70 days kicking this application around before they finally issued an official written denial. 70+ days.
It's as simple as that. They had violated their own governing documents. By taking way too long to make up their minds, they had accidentally and unknowingly approved the very gate they were fighting so hard to stop. The clock had simply run out on them.
So what's the big lesson here?
It's a really powerful reminder that in these kinds of disputes, especially ones that involve contracts or bylaws, the process, the how, can be so much more important than the substance, the what.
So here's the play-by-play of how they won. First, the HOA completely blew past that 45-day deadline. Second, because of that failure, the community's own rules said the application was automatically approved. And third, the judge really had no choice but to enforce the HOA's rules against them, ordering them to approve the gate. And, the cherry on top, they had to pay back the homeowners $1,100 in filing fees.
This chart just perfectly sums up the whole paradox. On the actual merits, the arguments about the gate, the judge found that the homeowners had failed to prove their case. Based on the arguments alone, the HOA should have won. But on procedure, the HOA had failed to act in time, and in this case, the procedural mistake trumped everything else.
So, what can we all take away from this wild story? First, you have got to know your rules. Read your contracts, your HOA agreements, your lease. The details matter. Second, deadlines are not suggestions. They have real legal consequences. Third, procedure isn't just red tape. A lot of the time, it's the whole ballgame. And finally, document everything. A clear paper trail is always your best friend.
In the end, it really leaves you with a fascinating question, doesn't it? Was this a just outcome because the rules as written were followed? Or did these homeowners just get incredibly lucky because their HOA wasn't paying close enough attention? Either way, it is a powerful reminder that sometimes the most important words in any agreement are hidden in the fine print.